Well, next topic is not on the agenda. I want to talk about is the in Rem Properties. Town Attorney Noto.
Are we going to take action on anything, or we're just talking?
Well, let's talk about it.
I handed up again a copy of a memo I handed out on the 23rd. Now this is briefly just a follow-up from the conversation we had at the last board meeting when I explained that we will have title to these properties within a matter of days. The deed has been prepared and should be filed. So the properties that did not answer and did not pay are now going to be in the town's ownership. And as I explained at the last meeting, in order to sell them, if that is your choice, and that's a policy decision the board will have to make, there was this issue about why title companies don't insure for a 2-year period, and that's because in the Real Property Tax Law, Section 1137, the law provides that the deed that you receive shall be presumptive evidence. It's presumptively valid, meaning there's a presumption that it's a perfectly valid deed. All the notice requirements were met before the judge signed the order, et cetera, et cetera. However, after 2 years, it becomes conclusive, meaning essentially what this is it operates as sort of a 2-year statute of limitations for an aggrieved homeowner or property owner who lost their house in a foreclosure to bring an action. Now, that doesn't mean if they bring an action they're going to win. Some of you who read the Journal News might have seen that case in Lewisboro where a gentleman lost his house in an in rem foreclosure. He was involved in an ongoing dispute with the town, and the court returned the house to him. But he had to pay the taxes, of course. So that's where that 2-year period came from. And that's why we did check. Bishop checked with some title companies. They're all the same. That by and large, for 2 years, they don't provide title insurance.
By and large, or they don't?
They don't. I mean, we've yet to find one that does. Let me put it that way. Okay. So that being the case, as you will now have these properties, there's a couple of options. I did recommend that we accelerate that RFP process to get some real estate companies to evaluate them and make some recommendations to us. If and when you decide to sell them, they have to be sold at a public auction. And at that time, we would recoup, obviously, the taxes and the penalties and other monies. Bishop, on his own initiative, went to Poughkeepsie to an auction sale where Dutchess County was auctioning out in Rem properties. It was quite active. He learned quite a bit. There are professional companies that do this, obviously for a fee. And their experience has been very positive. The municipalities that we have a list of all the municipalities that have used them. They all seem very happy because obviously it takes a lot of the responsibility off the municipality, but also you make a lot of money.
What kind of fee do they charge?
I'll let Bishop get into that when he makes his presentation. But the issue is this: so you will own these properties. Which means you are also owner of the liabilities. There are people living in some of these homes. You're responsible for the ad valorem county sewer tax. You are liable. If anyone falls and breaks their leg, you're going to be a likely defendant in that action. So
thanks for bringing that up on the meeting.
So for what it's worth, you are now going to be landlords, and it's going to be a policy question whether the board wants to evaluate them, get them up for auction quickly, which you can do, or hold them and try and collect rent and enter into agreements, or put it out to a management firm. There are plenty of real estate management companies, and let them manage the properties for the town, also for a fee, and they would collect the rents and then pay the town the rents and take their fee out of that. There's a couple of options. I think the board needs to have a fairly vigorous discussion about it, and then give us staff some direction as to where you'd like to go. Well, let me I'll shift to the other batch of properties, those who have answered and not paid. I made a motion for summary judgment on those items, which is returnable on November 13th. I gave them an extra week, and one has paid in the interim. So
that was 18 or 19 properties.
Yeah, it's about 17.
17.
Yeah, and that. So essentially their new date of redemption is November 13th, 2009. If they don't pay by then, the judge, it's fully submitted to the court, and then the judge makes a decision. But
Wait, so we may be taking on another 17 properties?
well, I don't think we would. I think that most of them will pay. These are people that hired lawyers for the most part and needed more time to pay. I think most of them will pay. But I could be wrong because I'm quite shocked that up until now we haven't received more than we did. So I mean, I get lots of phone calls. They all have reasons why they're not paying, but they stand to lose quite a bit of equity. These are much nicer properties than the batch that we've already got title to.
So just, if I don't understand, why can't they simply borrow if they have a house? Because if they have loans to an existing bank, the bank would pay them.
Right. These are non-bank properties. These are people who own it and have equity.
I mean, it seems to me implausible that they wouldn't borrow money from a bank.
Some are for sale. Some are on the market thinking they're going to get a sale. And I said, you're not going to get a closing between now and the 13th of November. Borrowing money today is a little more challenging under this environment. Banks are far less likely to loan money, particularly on a property of which is a lien and a foreclosure pending. Everyone has an issue. I mean, like I said, when I write a book, Nick and I could probably tell you quite a few, very compelling stories about why people are having difficulty, and some of them are, legitimate, just, hard times. This is a tough economy, and so I think we may end up owning a few of those homes. I'm not sure all of them. I suspect many of them will meet the deadline.
Okay, I want to break it down into the two categories. So
Right.
we currently have 13 properties that are on the verge of.
No.
It says 13.
10. The ones we're getting, and those, I think it's about 9 properties, because one did pay. So, and remember, 3 of them were.
How many are residential?
I think there were like 7 homes.
8 homes.
Or 8 homes.
8 homes, 2 vacant.
Right, 2 vacant lots and 1 commercial building. So, and I think my conversation or our conversation with Mitch today, there was an assessed value of about 3.5.
3.5.
Right, roughly $3.5 million of assessed value per our assessment office.
That's 11. How many people are living, of the 8 homes, how many of them have people living
I
in
don't
them?
know. Mitchell knows. Mitchell went out and checked them all. I don't know.
We
But you got to come on the mic.
sorry, I don't have my notes in front of me, but nevertheless, we drove by all of the residential properties, took photographs, looked at them. There are clearly a number of them that appear to be occupied. We saw cars in the driveway. They seem to be occupied. There were several that were questionable.
What does that mean, questionable? What do you mean?
It's difficult to discern from the public right-of-way if someone lives there or not. If no one's home or no one's walking out or there's no mail or no newspaper, sometimes you can't really be sure. None of them were boarded up. None of them were obviously vacant, but there were a couple that just popped up at us as being perhaps vacant, but we couldn't tell.
Do we know who the owners of these properties are?
Yes?
Yeah.
And have we been in touch with them?
Absolutely. By law, we're required to notice them of the foreclosure. So yeah, they've all.
Do we know that they've received those notices?
Well, I have sent them notices as required by the statute. So they've gotten certified mail. They've gotten it by regular mail. They've gotten letters.
But none of these people responded.
None of them responded.
All right. Now, because I have 2 reasons for the questions. One is you're saying that the court or risk over the course of the next 2 years is they might allege that they received inadequate notice.
Correct.
So, I mean, do we have any obligation to find out if the people we have on record is the owner, are indeed the owners?
No, the only obligation we have is to notify the people who are listed in the title report and in the assessment office and the tax receiver's office as the record owner. And we also obligated to contact any mortgagees on the property, which we that's why we had title searches done on all these properties. All have received the same documentation, and we submitted affidavits of service to the court, and the court accepted it and granted our judgment. So, is it possible that somebody? I mean, quite frankly, you'd have to be pretty out of it, to not have been noticed. Now, people get noticed and ignore these things because that's what some people do,